And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The question we need to ask today is simple. What happens when the highest court in the land issues a unanimous 9-0 decision laying down a fundamental constitutional rule, and a federal circuit court just shrugs and pretends they didn't hear it? Imagine this scenario. An officer uses deadly force. The victim is dead. Now, the court that reviews this horrifying incident says, quite literally, that nothing that happened before the trigger was pulled matters. The only thing they care about is the single, terrifying split second when the officer believed his life was in danger. All the events leading up to that shooting, irrelevant. The officer's own actions that potentially escalated the situation, ignored. Now imagine the Supreme Court reviews that precise rule, analyzes the foundational law, and throws it out. A 9-0 vote, total unanimity. They explicitly tell the lower court, you got the law wrong. You must look at the totality of the circumstances. But here is where the legal story turns into pure drama, maybe even defiance. Because the lower court got the case back, looked at the Supreme Court's clear instructions, and then issued a new ruling saying, yeah, we saw what you said, but we're sticking to our original outcome anyway. This isn't a hypothetical legal exercise. This is exactly what is currently happening in a critical case involving the Fourth Amendment and the parameters of police force. This case, Barnes versus Felix Tsekix, is now barreling back toward the Supreme Court just months after they already settled the law. The consequences of this judicial defiance are huge. We need to understand the facts, the law, and why the Fifth Circuit is essentially daring the Supreme Court to rule against them a second time. For the 5-second tragedy on the highway. The case began with something remarkably mundane, alleged toll violations. The victim in this case was Ashton Barnes. He was driving a rental car in the Houston area. An officer named Felix pulled him over. This was not a pursuit of a dangerous felon. This was a traffic stop related to cameras picking up unpaid tolls. Officer Felix instructed Barnes to exit the vehicle. Barnes opened the door, acted as if he was complying, and then made a terrible, fatal decision. He got back in the car and tried to drive away. That decision ignited a chain of events that lasted maybe 5 seconds, but which sealed Barnes's fate. Reacting immediately, Officer Felix made his own horrifying judgment call. He jumped onto the side ledge of the accelerating car. Think about that for a minute. An officer, alone, hangs onto the outside of a moving vehicle that is actively trying to escape a traffic stop. As the car continued to flee, with the officer clinging to the exterior, Felix fired 2 shots at Ashton Barnes. Barnes died at the scene. His mother initiated a lawsuit, arguing that Officer Felix violated Barnes's Fourth Amendment right against excessive force. The claim here is critical. Was the use of deadly force objectively reasonable under the circumstances? The District Court and then the Fifth Circuit Court of Appeals initially sided completely with the officer. They granted summary judgment, meaning the case was dismissed before it ever got to a jury. The Fifth Circuit's shortcut. The moment of threat rule. The reason they dismissed the case is the legal poison the Supreme Court just tried to neutralize. It was called the moment of threat rule. What is this rule? It's a legal shortcut, popular in some circuits, which says that courts only need to ask one question. Was the officer in danger at the precise moment the trigger was pulled? Under this narrow, hyper-focused rule, all the events that led to that moment are thrown out. Did the officer unnecessarily escalate the confrontation? Did the officer introduce the danger himself by jumping onto a moving vehicle? The answer, according to the Fifth Circuit's initial ruling, was that those questions simply weren't relevant. They were arguing that by jumping onto the car, the officer was clearly in danger and therefore using deadly force to eliminate the threat, himself being dragged or thrown from a vehicle, was justified. This analysis completely ignores context. It ignores human behavior. It turns a dynamic, evolving situation into a static photograph of only the final second. That is why the Supreme Court stepped in. Ortiz, the unanimous correction. The case, Storms, Barnes vs. Felix, made its way up the judicial ladder. And when the justices reviewed the Fifth Circuit's application of the law, they didn't split 5-4. They didn't issue a messy, conditional ruling. They issued a 9-0 unanimous decision against the Fifth Circuit's approach. The Supreme Court held firmly that when analyzing excessive force claims under the Fourth Amendment, you must apply the totality of the circumstances test. This objective reasonableness standard, established decades ago in Graham versus Connor, requires a deep dive into every fact and circumstance related to the incident. I know what you're thinking, but hear me out. The Supreme Court stressed that the inquiry has no time limit. Yes, the situation at the precise moment of the shooting is often the most important factor, but prior events are essential. Why? because they show how a reasonable officer would have understood or responded to later events. Prior events can distinguish whether conduct was innocuous or truly threatening. They reveal the officer's own role in creating the deadly scenario. The justices made it crystal clear. Reject the limited moment of threat snapshot. Use the wide-angle lens of the totality test. Based on this powerful, undisputed ruling, the Supreme Court vacated the lower court's judgment and remanded the case. They sent it back down to the Fifth Circuit, saying, "Do it again, and do it right this time, using the correct legal standard." If you're finding this analysis helpful, please take a second to like this video and subscribe to Law Advisor. It helps us keep these deep dives coming. Now back to the case. The stunning act of defiance. You would assume that receiving a 9-0 smackdown from the Supreme Court on a fundamental question of constitutional law would prompt a federal circuit court to act with extreme caution and diligence. You would assume they would request new legal briefs from both sides, asking them to apply their arguments to the newly validated totality standard. You would expect new oral arguments. The Fifth Circuit did none of that. The 3-judge panel that received the case back from SCOTUS made a truly unprecedented decision. They reruled the case on their own, without additional briefs or oral arguments. They simply looked at the original facts under the totality standard and ruled again in favor of Officer Felix. This is judicial expediency bordering on outright contempt. They essentially said, "Thanks for the lesson, Supreme Court. We still believe we were right the first time, and we don't need to hear from the parties involved." In their new ruling, the panel held that even under the mandated totality of the circumstances approach, the officer's actions were warranted. Their reasoning was simple, and in its simplicity, profoundly dangerous. They reasoned that any vehicle flight creates a deadly threat, and therefore, the officer reasonably used lethal force to prevent a dangerous high-speed chase. Or wasn't the legal loophole, creating a per se rule. Wait, let's look at that again. What the Fifth Circuit did here was take the Supreme Court's totality test, a test designed to be nuanced, context-specific, and jury-friendly, and warp it back into a simplistic shortcut. They created a de facto per se rule. If a suspect attempts to flee in a vehicle, an officer is automatically justified in using deadly force. This completely undercuts the very purpose of the Fourth Amendment analysis. If the initial stop was for toll violations, a relatively minor infraction, does the act of speeding away suddenly justify lethal force in every instance, regardless of the danger to the public, or lack thereof, at that exact moment? The attorneys for Ashton Barnes's family immediately petitioned for an en banc rehearing. An en banc hearing means all the judges of the entire Fifth Circuit would sit together to review the panel's decision, a sign that the issue is so critical it needs the consensus of the whole court. The petition argued that this new panel ruling contradicts not only the new Supreme Court instruction, but also decades of established precedent within the Fifth Circuit itself, which long held that fleeing in a vehicle does not automatically justify deadly force. If the Fifth Circuit's latest ruling stands, it creates an enormous loophole. It empowers an officer to shoot anyone fleeing a traffic stop, regardless of whether the car is driven erratically or if the officer has put themselves directly in harm's way unnecessarily. Consider the facts the Supreme Court wanted the panel to analyze under the totality test. 1. The severity of the crime. Toll violations are not a capital offense, they are minor. 2. The officer's escalation. Was it objectively reasonable for Officer Felix to jump onto the side of the fleeing car, thus creating an immediate and grave threat to his own life and placing him in a position where deadly force was the only perceived exit? 3. The threat to the public. Was Barnes driving so dangerously that he posed an immediate threat to the community, a threat Felix had to neutralize with lethal force right then and there? Or was he just trying to get away? The Fifth Circuit panel, by issuing their ruling without argument, effectively dismissed the relevance of points 1 and 2. They focused only on the perceived threat of a dangerous chase, asserting that because a car chase can be dangerous, the use of deadly force to prevent its commencement is justified. The denial of en banc review. And this is the final baffling step in the saga. When the petition for an en banc rehearing reached the full body of the Fifth Circuit judges, they denied review. They confirmed the decision of the 3-judge panel. This denial sends a powerful, unsettling message. It suggests that a majority of the Fifth Circuit judges are comfortable with this new, extremely permissive standard for the use of deadly force, a standard that appears to fly directly in the face of the unanimous SCOTUS mandate. The implication here is massive. This isn't just about one dead man in Houston. This is about defining the constitutional limits of policing across Texas, Louisiana, and Mississippi, the states covered by the Fifth Circuit. A federal appeals court has essentially told the highest court, "We heard you, but we disagree with the implementation, and we are going to rule in a way that minimizes the impact of your decision." The outcome of this denial means the case is now perfectly primed to go back to the Supreme Court. The parties have already litigated the constitutional standard. The Supreme Court has already ruled 9-0 on the constitutional standard. Now, the question that will face the 9 justices is, did the Fifth Circuit comply with our mandate, or did they deliberately circumvent it? The second review is rare, and it's tense. The Supreme Court might view this as a test of their own authority. If they let a circuit court get away with this kind of noncompliance, it opens the door for other circuits to ignore mandates they find politically or ideologically inconvenient. We are now waiting for Barnes's attorneys to file a new petition for a writ of certiorari, asking the Supreme Court to take the case again. They will argue that the Fifth Circuit, by creating this per se rule for fleeing vehicles, failed to properly apply the totality of the circumstances test as required by the 9-0 ruling. The stakes could not be higher. If the Supreme Court takes this case back, they will have the opportunity to define, with even more precision, exactly what kind of context, what kind of officer escalation must be considered when analyzing excessive force. They will have to clarify whether the simple attempt to flee a minor traffic violation can be met with lethal force, or if the officer's own conduct in physically inserting himself into the danger zone must be factored into the reasonableness equation. This case is a crucial battleground for the Fourth Amendment. It demonstrates that the battle is often not just about what the law says, but whether lower courts choose to obey it. The fate of excessive force law now rests on whether the Supreme Court is willing to rein in a circuit court that has effectively issued a direct challenge to their authority. We will be watching closely as this develops, and will update you immediately as the petition is filed. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I'll see you in the next one.